So my mother is deceased, owned a house which is still on her name, but remarried. So she must have obviously remarried beforehand. My two siblings and I are wanting to know, since my mother got married in community of property, do we have any claim to the house? My stepfather is also speaking about putting the house on someone else's name. Okay, so that starts making sense. Can he do this? So yeah, house. So the owner's deceased. It wasn't her name, but they were married in community of property. There's two siblings and the stepfather, and there seems to be a dispute over the house.
Yes. So I assume there isn't a will in place. So your mum obviously passed interstate, and I'm very sorry for your mum, for you about your mum's passing. The thing is, so interstate, it depends on the entire estate. So because the parties, so a spouse, especially married in community of property, obviously that part of the estate has to be dealt with first. So if there wasn't a will and she passed on interstate, it means we now need to look at the entire estate, divide it equally between the spouse and then the children, and we call that a kindsdeel in Afrikaans. I don't even know what's that part called in English. A kindsdeel, the part that the kids inherit.
Child's share.
A child share. It's actually not a difficult translation from kindsdeel to child share, but anyway, point being, the spouse is entitled to their half of the joint estate, because remember, in the context of a marriage in community of property, half of that estate must go to the spouse, the surviving spouse. Then we take the rest of the estate, the remaining half, and that we divide between the children and the spouse. So the truth is, your stepfather at this stage, based on the interstate situation, owns his half share, undivided half share, as well as a bit more, being the part divided between you and your siblings, as well as him. He is entitled to the same as the children, plus a little bit. So it's not as simple as putting the property on somebody else's name. I can't see that he would be allowed to do that unless he owns the entire property, which he can't, because if there is a will, and your mum bequeathed her estate to him, obviously he can, and then he can take transfer of the remaining half share in terms of the will, but it doesn't sound like that's the case. So in this particular context, he won't be able to transfer the property to somebody else's name in full, because I do believe you are entitled to at least a portion of the remaining, your mother's half share of the property. The problem is, when it comes to something like this, people tend to transfer and sell before they sort out the actual true underlying issue, being how do we deal with this? How do we compensate one another? And very often, and I'm very logical when it comes to these things, and very realistic. So bear with my unemotional, realistic approach. I'm pragmatic when it comes to these things. Don't fall into the typical trap when it comes to property in succession, where you are so focused on where does the house go, that all the other potential parts of the inheritance are completely missed. Very often, these fights about a house in a deceased estate can drag on for 12, 15 years. It means it ruins relationships between family members unnecessarily so. So have a look at the full estate. I would definitely suggest that you get to an attorney who can sit down with you and do the actual full calculation. Are there any policies that has to come in? Is there a bond on this property? Because remember, if you inherit a property that's still bonded, but there wasn't a policy to settle the bond, you're inheriting more problems than solutions. So very often there are things that you might not want to inherit. So I would suggest that you get to somebody who can sit down, really look at this estate for you, see what there is. If the house is the only asset, I would definitely rather suggest that you get into a mediation sort of situation with your stepfather, rather have him buy you guys out, take the case. Yes, I know there's an emotional attachment to a property, but it's the emotional attachments to properties that tend to, in the long run, ruin relationships between family members. And I'm sorry to be that person, but relationships are worth much more than properties. And I say that with a deep love for property and property law. So just be careful to not focus so exclusively on the house that you miss all the other potential solutions. But I would definitely, if he wants to transfer the property and there isn't a will, you would be able to stop that with an urgent application. Once again, just because we can do something in law doesn't mean it's the wisest decision. Litigation is expensive, and unless you know that you are fine to litigate for 2 or 3 years on something, and you might not get exactly what you want, I would be very careful of dipping into that. But we can stop him from transferring. I do believe you might have a right to at least a portion of the property, but I wouldn't say it's worth fighting tooth and nail for something that we don't know exactly what else is in the estate.
Absolutely. Another interesting question. I suppose it depends how her previous marriage and how that was structured, but is there a possibility that this property was excluded from community of property? Because that would be something to look at. So it can be done. It takes a bit of effort, but it can be done where a specific asset is excluded. I know that with wills, there was a court case at a stage saying that it's not right because people used to leave assets to others, but subject to those assets not forming part of the current community of property or future community of property. Yes. So if that is something, Cilna, I don't know if you have any experience with that.
I've seen that, and I know about the case law you're talking about, where you can, and I mean, I've seen that, we've seen that quite a few times, especially in the past, where there's an inheritance from a parent to a child, and that inheritance is then excluded from any joint estate. And I remember a case, I can't remember the name of the case. I just remember the judges repeatedly said, you can't rule from the grave. You shouldn't be ruling from the grave. And that's, I don't think it's illegal and unenforceable, but it is definitely a little frowned upon.
It is. But yeah, so it's definitely something to look at. So Carla, if there's a possibility of this, and if you go back in time to when the property was registered in your mom's name, that might be something to look at. Whether it's enforceable or not, well, you heard it from us, it would really depend. And yeah, I'm even happy to get Bruce to have a conversation around it if there is a follow-up to this.
Yeah, that's a good idea.